Well, it's wonderful to be home. It's wonderful to be back in Canada, and it's a particular privilege to be speaking today at the Global Center for Pluralism. Secretary General John McNee is done just a remarkable job in getting the center off the ground, and it's wonderful that we're able to partner with him and his team as they drive forward with their mission. And it's a particular privilege to work with him, and I'm grateful for the opportunity. So I'm going to speak for about maybe 15 or 20 minutes about group rights. And as John said, the kind of the central question I want to explore is what they're about, what motivates them, and what drives them. And so maybe I should begin by talking about the kind of society that I'm interested in. And so this is a center for global pluralism, and so most societies are plural or have pluralism of a cultural or religious or linguistic kind. And so what I'm interested in is a subset of those societies in which pluralism has become politically activated. So pluralism serves as the basis for organizing and thinking about politics. And in those societies, we call those societies divided societies, right? But that's not to say that they're irredeemably divided. That's not to say that there's walls built up around communities. But the character of politics in those societies is different than one would find in societies where pluralism hasn't been activated as the way to organize and refract and make political claims. And so what one sees in a lot of divided societies is that as part of the complex range of claims that groups and individuals make in politics are a cluster of claims that fall under the heading of group rights. And group rights is sort of an umbrella category, okay? And underneath it are a multiplicity of particular claims. So you might see claims for group rights to govern rules or to set rules governing internal migration between states or regions within a country, rules governing land ownership, rules governing access or preferential access to public services, to public housing, to public sector employment. All sorts of policies and debates about language policy, which Canadians are very familiar with, whether for official language status, for bilingualism, for access to services in certain languages. Again, those are often described as certain types of group rights. Indigenous rights, the rights of Aboriginal peoples, of First Nations, again, a set of claims to land and resources and consultation are another set of claims that fall under the heading of group rights. And of course, the rights of religious minorities to certain forms of accommodation, be they the right to wear religious symbols or religious clothing in public sector employment, which is, of course, a singularly controversial issue right now in Canada, but also the right to govern their marriages and questions of divorce and succession according to religious personal law. Again, these often are framed in the language of group rights. And so group rights are pervasive. They're a pervasive part of politics in many societies. There's many different types of claims for group rights that one sees. And so the question I want to ask today is to stand back from these particulars and ask what motivates these claims, right? Why do we see these types of claims in constitutional politics around the world? And then what are these claims in legal terms, because I am a lawyer, and what's interesting is that one sees claims for group rights frequently in constitutional negotiations, and so what, legally speaking, is being demanded in the form of a group right? And then how do we manage the conflict that we might have or we might see between a group right and an individual right or individual rights? And what is the character of those conflicts? And so before I give you the answers in outline, let me kind of explain why it's important that we ask these questions. And so there's sort of practical reasons and there's academic reasons. And so the practical reason is that a lot of us work with organizations or run organizations like John and I do that are involved, broadly speaking, in the world of democratization, democracy promotion, constitution building, conflict resolution, and so forth. And so as practitioners, we confront these kinds of claims all the time in the field. And we're called upon to provide technical advice to constitution-building processes about how to deal with these issues. And we firmly believe that technical advice should be grounded in good knowledge. And in particular, it should be grounded in a good understanding of what is at the root of certain political claims, because you cannot give good support and good advice unless you know what's going on. And so having a sense of what the basis is of claims for group rights is essential to being effective in those contexts. And that's a lesson that's important not just for advisors, but for NGOs, for INGOs, for governments, for organizations like CETA, IDRC, et cetera, and so forth. We all need to understand what's happening before we get engaged and can provide support when we're called upon to provide it. So that's the practical reason number one. Practical reason number two is that what happens is that let's say there is a constitution that results from some type of a process, and it contains group rights of some form. It will almost certainly contain some or all of the standard schedule of liberal rights and freedoms that one sees in documents like the Charter. And the interesting question, and so these are rights that you would be familiar to all of you: freedom of expression, freedom of association, freedom of religion, rights of non-discrimination, due process rights, and so on and so forth. And so there is this sense in which, in very concrete ways, that there can be a clash between the exercise of a group right and an exercise of an individual right. And that's how people often understand these rights. They say, well, the problem with group rights is that they inevitably conflict with individual rights, and that's a terrible thing. And so to which my response is, we should at least understand what the nature of that conflict is. How precisely do they clash with each other? In what context? In which ways? So that we can then figure out how to reconcile or resolve those conflicts, if it's possible to do so. And so having an understanding, again, of what the basis for claims of group rights are is a precondition for engaging in that sort of downstream exercise, which arises in all developing and mature constitutional systems, including this one, right? We need a sense of what these rights are about, what motivates them, and why they're there, before we can interpret them and try to reconcile or resolve conflicts between them, okay? And the third reason is that I firmly believe that as an academic, that when we think and theorize about group rights, we have to learn from constitutional practice. And so I'm going to be giving lots of examples to try to illustrate the point. And what's often the case is that folks in the field who are working on these issues on the ground often have knowledge that we need to systematize and capture and make and render kind of explicit in a more conceptual way. And that's part of what I'm trying to do today. And it's part of a partnership between policy-related organizations and universities and scholars like myself. Okay. So what is the answer to this question? So the answer to this question is that there is a huge degree of misunderstanding over what group rights are. And so there is an account I'm going to give you let's call it the standard account. And then there is this contrary answer that I want to present to you. So the accounts differ on what motivates these claims, what are these claims, and how they conflict with individual rights. Okay? And so what the standard account of group rights is that what motivates them are claims for cultural difference, cultural distinctiveness, and they are, and so there are perceived or actual threats to cultural survival or cultural integrity that are ultimately at the root of claims for group rights. And as Canadians, we all know this, right? Because this is often the way in which you think about the politics of Quebec nationalism. And these debates about recognition and respect and distinctiveness and specificity and all the terms we've invented over our decades of struggling with this issue are really rooted in this way of understanding what's at stake in certain types of debates about group rights in this country. And what I want to argue is that in contrast to this cultural understanding of what a group right is, we have to have a more material understanding of what motivates claims for group rights, and when we see political mobilization in the name of group rights, what underpins that mobilization is often not cultural survival or concerns about cultural survival, or not just those claims, but grievances about unequal enjoyment of public services, unequal access to economic opportunities, unequal access to economic resources, an unequal political power underlying all of that. And so the basis so what group rights are really about then is not culture, but economic and political power in many contexts. And we misread those contexts if we think that they are all debates about identity. They're not. They often are, but they're not. And if we don't understand what they're about, we can't give the right advice for how to address these concerns. Point number two. So what types of rights are then claimed under the rubric of group rights? So the standard account says that group rights are rights to collective decision-making by a group, a national minority, a religious minority, an indigenous minority, some type of authority, some political authority on the part of that group over matters that are integral to their cultural survival. It is a right that is exercised collectively. It is a right that is exercised through institutions. Those institutions might be democratically elected, like a provincial government, or they might be unelected, as in the case of religious leadership of religious institutions. But the point is that they are collective rights exercised through certain mechanisms over specific subject areas integral to cultural survival, like language or religion or so on. Okay. And so what I want to argue in response to that is that that's certainly one set of claims that one sees, but one should put those aside or alongside other types of claims that one sees in the name of group rights, which are not about cultural autonomy and rights to self-government and separateness, but really about rights to participate in shared institutions on fair terms. And so the claim is to ensure that groups who have faced disadvantage or grievances, economic and political, have fair access to political power, to ensure that they can protect their interests. And these group rights, as they were, take a lot of different forms. As we'll see, sometimes they're exemptions from laws, sometimes they're accommodations that exist alongside laws, sometimes they're facially neutral rules that don't actually refer to a group. But the reason to have them is because of concerns about group disadvantage. And these claims arise in different contexts. They arise in federalism, but they also arise in electoral system design. They arise in the complex set of rules that govern the formation of political parties, which is a very contested issue in many democracies, particularly transitional ones. These arise in the context of how legislatures vote and the rules governing how they vote, special majority rules, double majority rules, both. They arise with respect to the rules that govern the composition of the political executive, in how the executive is chosen by the legislature in a parliamentary system. That's not a straightforward thing in many cases, and often it's at the heart of debates over group rights. Who has power? Who's a minister? Who's at the cabinet table? And then finally, even on the composition of constitutional courts. As we know in Canada, we have 3 judges who are, as a matter of statute and arguably as a matter of constitutional law, from Quebec, members of the civil law bar, and that type of arrangement of having a diverse court in a diverse society is something one sees in other countries as well, Belgium and Kosovo and Bosnia and many others as well. So that's the argument in summary. So let me now kind of turn to some examples. So on this issue of what motivates, what interest is at stake in claims about group rights, the example I think that makes this point best is official language policy. And I picked this example because in Canada, we live with this every day. And debates about official language policy are tightly wound up with debates about the nature of this country, Quebec's relationship in it, and the role of Francophone communities as citizens of Canada, as well as citizens of Quebec. And so the standard account that in many ways kind of grew out of Canada's experience in wrestling with minority nationalism in the 60s and the 70s and the 80s and the 90s, offered up by brilliant students of politics like Alan Cairns and Will Kimlicka and others whom will all be known to you, is essentially what motivates these kind of claims for a language status are claims about culture, about cultural identity, about cultural survival. And that's how we should understand what's at the root of the politics of language. And so the counter account that I want to give is that really, in many cases, mobilization around official language policy is driven by material concerns. And official language status has distributional power. It operates to distribute both political and economic power. And where the rubber hits the road, as it were, with respect to the economic effects of official language policy is in how it regulates access to public sector employment. Okay? The internal working language of government determines who can work in government. It determines who is qualified to enter the civil service and eventually to rise to positions of authority and leadership. And in many, many linguistically divided societies, debates about official language policy have been at the center of debates over group rights. And what has driven them is who gets access to the public sector and the economic rewards that it provides, and as well, who has access through that to the political power that comes from office holding in the executive branch, in ministries, but also actually in parliaments or in legislatures. And so the motivation here for assertions of group rights under the rubric of language rights is principally economic and political. And perhaps the best laboratory for that point is South Asia, right? So in the post-colonial period in South Asia, in Pakistan and Bangladesh and India and Sri Lanka, to a lesser extent in Nepal, although it's very much there, the principal driver of the reconfiguration of political space has been language. It was language that led to the breakup of Pakistan into Pakistan and Bangladesh. It was language that led to the reconfiguration of Indian states in the 50s and the 60s from boundaries drawn by the British on administrative lines that were indifferent to linguistic boundaries, to boundaries that roughly track language groups. It was language that lay at the root of the civil war in Sri Lanka, with official language policies adopted in the 50s by the government, and then that pursued into higher education, and ultimately led to the exclusion of large number of Tamils from public sector employment and universities. And so what drove this type of politics across South Asia was all very different. Every country is different, but there was a common element to it. Kind of in a post-colonial context, with mass education in the vernacular, in local languages, with youth who came out of these schools with rising expectations for what they wanted to do with their lives. The rural lifestyle was no longer good enough for them. And this led to kind of migration to cities and political mobilization for access to what was a very valuable economic opportunity, access to working for government. And ultimately, language policy became this site of conflict or contest in all these societies over who got in. And debates about official language policy were driven by political parties representing different groups who often would voice claims in the name of culture or identity, but really what motivated and energized politics around these issues were jobs. And so language policy in this kind of post-colonial space has been driven largely by economics. That's not to say it doesn't have cultural consequences. That's not to say that the conflict that one sees is not between culturally distinct groups. But just because culture is there, just because groups are culturally different, just because those groups are in conflict with each other, does not make the dispute about culture or about identity. It might be about something else. And so one can take that general point that political conflict between culturally distinct groups that might disagree fundamentally on the way to live their lives might not be about their cultural differences. It might be about something else. So let me give you an example from China. So as many of you know, in China, we've witnessed mass migration of Han Chinese into Tibet and Jiangxing. And this has led to a great deal of conflict in Tibet and Jiangxing. There have been ethnic riots. And this is a situation that's not stable. What is driving this? What is driving this debate? So one way to read what's happening in China is a conflict fueled by internal migration between different economic modes of production. So a modern, urban, industrial economy coming in as a matter of Chinese state policy on the backs of or through the encouragement of internal migration into parts of China where you have a traditional, rural, urban society with a different way of organizing the economy and whose language and skills don't equip them to participate in this economy on fair terms. And so the conflicts there are between different ethnic groups who speak different languages, who are culturally very different from each other, but what the spark is economic grievance, mixed up with culture that might fuel cultural disputes, but ultimately what energizes it is economics and economic opportunity. And one can look, again, around the world at debates over access to natural resources, over traditional fishing grounds, traditional grazing grounds, cross-border smuggling routes in Libya, just to pick an example that occurred to me the other day. Again, these are conflicts often between economies organized around ethnicity, where there are competition between different ethnic groups over resources, and that becomes a form of economic conflict. So that's one big point. So what kind of rights, then, should one expect to see in this world of group rights? So the standard account says, as I said, that there are minority groups that seek to respect their cultural distinctiveness, and they assert rights to self-government or rights to autonomy held collectively, exercised through its own institutions or their own leadership over matters integral to their cultural survival, over language, over religion, over indigenous status, etc. Okay. What I want to suggest is that there's another way to think about what group rights claims are about, and what they're about is access to political power, motivated by these disputes over access to economic opportunities and resources and political power. And so the claim then is for the fair distribution of economic and political resources, or a different distribution of economic and political resources. And where this cashes out at the technical level is in claims for federalism, how electoral systems are designed, how political parties are formed and the rules governing political party formation, how legislatures vote, and the composition of the political executive. So let me give you some quick examples. So in terms of federalism and creating new states or subunits for economic reasons, as some of you might know, in India, in 2000, there were 3 new states created by carving out or dividing existing states. These are Chhattisgarh, Jharkhand, and Uttarakhand. And so the question is, what was the basis for this? Why create these new states? What was the mobilization for it? It wasn't something that was top-down, done for the reason of administrative convenience. It was based in response, after years of resisting it, to popular political mobilization, electoral campaigns by parties, violence in some cases. And the answer was neglect, economic underdevelopment, poor infrastructure, a sense that the state capital was distant, was dominated by elites who are not the elites of that territory. So this idea of kind of neglect and distance and underinvestment and indifference is often at the root of regionalism. And it might be that to motivate and mobilize a population, there are claims about culture and identity that are made by political parties, but that's not ultimately what gets these movements off the ground in many cases. Very quickly, before I wrap up, there are another set of debates we could have, or discussions we could have about electoral system design and how that can operate as a way, as an impediment to group rights. And claims for the redesign of electoral systems can often be framed in the language of group rights. So the example I'll give you is of Turkey, right? So Turkey has a PR electoral system, has a very high threshold, 10%, highest in the Council of Europe. That threshold operates to systematically disadvantage Kurdish political parties from doing well in Turkish national politics. It's designed to do that. Okay? And so Kurds and Kurdish political parties mobilize, assert group rights, and their target is that threshold. And so what's the solution, right? In some cases, it might be just to lower the threshold. In other cases, for everyone, in a facially neutral way that every political party can benefit from, but which is done in a group-conscious way in order to facilitate and encourage political participation of those parties. And that's essentially what happened in South Africa, where there is no threshold for the electoral system, in part to enable political parties representing certain racial and ethnic groups to at least be represented in the parliament, as opposed to being outside of politics entirely, which is more dangerous. In other cases, there might be exemptions, that group-specific exemptions of certain types of parties. So in Germany, sometimes the threshold is waived for certain minority parties. In other cases, can be seats set aside for minority groups, as occurs in Eastern and Central Europe in some countries. So the point being that these are all different types of claims for group rights. Their target is all entirely political power. And the mechanisms by which these claims can be accommodated might often bear very little connection or might seem completely unrecognizable to someone who is thinking about group rights in terms of culture, in terms of identity, in terms of cultural survival. Right? There are a whole range of other types of tools and devices that we see in constitutions that are designed to protect the political interests of groups that don't look anything like the group rights that you and I might think exist. So let me conclude by saying, so what's the payoff here? What's the benefit of engaging in this analysis, and where do we leave things? So there's 2 points I want to make. The first is that given the pervasiveness of material motivations underlying claims for group rights, we should have a healthy skepticism whenever a group asserts culture as a reason for a group right, particularly if it's a reason to limit someone's individual rights. Okay, the motivation might not really be culture. It might be economic. And the way in which we assess the importance of that objective relative to the right that's been limited might be quite different when identity or cultural survival is on the table. Again, skepticism does not mean rejection. It means to be circumspect, to be alert, to be aware that there might be another story. That type of healthy skepticism is, I think, what constitutional law should be about. And so that's one kind of takeaway lesson. The other takeaway lesson is this, that when we think about group rights, I don't want you to think at the end of this lecture that I'm against the idea of group rights, or that I don't think they're necessary. They might be felt political necessities, particularly in a way to lubricate a transitional process, to encourage parties to participate in politics, to engage in the constitutional process, to lay down their arms, and to shift from hot conflict to cold conflict to some semblance of normal political competition and political life. And so group rights are a form of guarantee that are part of the toolkit of conflict mediation and conflict resolution and peace building. But so the interesting questions are not whether group rights or not, but how and for how long, and how we structure the relationship with individual rights. And those are the debates I think we need to have. And I think they are materially different debates when we understand that what often is at stake in claims for group rights is not questions of cultural identity or survival, but economic or material concerns, because there might be different ways we have for addressing those. Thank you very much.